Bill Cosby is once again being forced to face tough questioning. The comedian and his former lawyer will soon testify under oath in a defamation lawsuit brought on by former supermodel Janice Dickinson. Dickinson claims she was defamed by Cosby because he publicly accused her of lying about being drugged and raped by the comedian back in 1982. In July, Dickinson appeared on CNN. This is what she said.
There's no way to put into words the depth of misery, pain, and humiliation that I and the other women and all women and men that have gone through unconsented, non-consensual drugs and rape. It altered my behavior. My family's been embarrassed and humiliated.
The deposition is set to take place by November 25th. Cosby's team say they'll appeal, saying it was legally incorrect to allow the deposition to go forward. With me now is Janice Dickinson's attorney, Lisa Bloom. She's also a legal analyst for Avvo. Welcome.
Good morning.
Lisa, first of all, is Janice ready for this?
Janice is absolutely ready for this. Janice is strong. She has her tough days, like all survivors of sexual assault do, but she was absolutely elated by the court decision yesterday.
I understand the scope of the questions in both depositions is limited, so what topics will be out of bounds?
Well, we got everything we asked for yesterday, and my legal team and I spent a lot of time and effort on this motion, and this is a great victory for us and for Janice. We asked for limited depositions at this early phase of the litigation on the legal issue of malice. In a defamation case where somebody like Janice, who's a celebrity, is suing, we have to show malice, which means that the statements that Mr. Cosby and his attorney made about her, calling her a liar, after she came forward with her rape disclosure like 50 other women, we have to show that they knew that was false or that they should have known it was false. In the case of the attorney, that he failed to do an appropriate investigation. He came out the same day and attacked Janice Dickinson the same day that she came forward, November 18th, 2014. We contend he failed to do an appropriate investigation. He failed to consider Mr. Cosby's own admissions in depositions in 2005. And we think we have a pretty strong position, but I look forward to personally taking Mr. Cosby's deposition and his attorney's deposition to gather more evidence in support of Ms. Dickinson's case.
Okay, so I understand what you just said, but can you also question Mr. Cosby or his attorney about what happened back in 1982?
I think it's very likely that I can, because it's going to depend sort of on the flow of the questioning, and I don't want to reveal now and all of the questions that I'm going to ask and give a script to the other side so that they can prepare. But I think it's very likely, because in a defamation case, truth is a defense. And if Mr. Cosby is going to claim that he did not rape Ms. Dickinson, then I think that's an appropriate line of inquiry at a pretrial deposition.
Interesting. So you're also going to depose this attorney, but he's Cosby's attorney, and there is attorney-client privilege. So does the attorney have to answer your questions?
Well, he certainly does not have to answer questions about attorney-client privilege, and I respect that. And listen, I've taken probably hundreds of depositions in my career over the last 30 years. I understand the attorney-client privilege, but the attorney-client privilege does not apply to attorneys speaking to third parties like the media. It doesn't apply to attorneys speaking to people other than the client, such as a publicist. It doesn't apply to an attorney writing up a press release and sending it out. So I think there will be a lot of areas of inquiry that will be appropriate and that will be allowed.
So you could ask the attorney something like, you said in a press release that Ms. Dickinson was lying about what happened in 1982. And you can kind of poke him on that and get him to say whatever, correct?
That's right. And I can also ask him about the investigation that he did. So the attorney has already submitted a declaration in the case, which is a written statement. Everything that he wrote in that declaration is a fruitful line of inquiry for me. I can ask him about all of that. We don't have to just accept what he said. Of course, it's very easy to sit down and write out a statement and edit it and make it the way you want it. It's another thing to answer tough questions under cross-examination. And that's what the judge yesterday said that I am entitled to do.